What does that mean? It means I'm wearing a giant watch. We're out of time. We're out of time to get this case tried before the November election. There's just no way for all of what I've just described to happen at either level. Even if the case is returned, let's say they return it, there's an opinion of the Supreme Court, which is what it's called, and it comes on their last day before they all go for their well-paid, really expensive holiday vacations, whether it's a yacht or it's spending the summer in Italy or whatever it's going to be, on both sides of the aisle, by the way. Let's say they issue it in June. Judge Chutkan calls together a hearing of the lawyers in end of June, beginning of July. And she says, okay, I now have to do this process because I've been ordered to do it by my bosses of the United States Supreme Court. I want full briefing within the next 2 weeks. All right, now I'm in mid-July, oral argument end of July. She makes a ruling beginning of August. The loser takes an appeal. You see how long this is taking. It's taken 4 or 5 months to get to the Supreme Court. We've blown by November, and we've blown by this case getting tried before November. And if Donald Trump gets in office again, God help us, and he restores his presidency with this executive branch unitary theory of supremacy with this Supreme Court, he'll dismiss the Department of Justice case, he'll dismiss the special counsel, or he'll try to, and he'll dismiss the counts against him. And this Supreme Court, or at least the 5 or 6 votes I just identified, will be okay with it. That is the nature of what they ruled upon. So when I heard Kavanaugh say he's not concerned with the facts of this case, Gorsuch say, I don't care about the facts of this case, I'm thinking about the future and our legacy. Alito say, I'm not concerned about the facts of the case, I want to make this abstract and hypothetical. I knew we were in trouble. And then Roberts, who I held out some hope for, Roberts jumps in with, now you know who framed the issue on appeal. The sole issue on appeal, that was all that was supposed to be briefed and discussed, was whether, and I'm going to paraphrase it here, a former president enjoys absolute immunity for official conduct. And I was sort of right in predicting what happened here. Most of what was written by the Court of Appeals below, the 3-judge panel led by Judge Pan, Henderson, and Childs, it looks like the Supreme Court was okay with most of their analysis, but didn't like the way they handled whether there was absolute immunity for official conduct. In fact, a slightly annoyed Judge Roberts said to the advocates, particularly the advocate for the Department of Justice, what did you make of that point in the 60-page order below in which they said there is no absolute immunity for criminal conduct that could be prosecuted? And the advocate, Mr. Dreeben for the Department of Justice, said, well, I just see that as a tautology, Your Honor. And Roberts jumped on that and said, right, isn't that the problem? I don't like that it's a tautology. I don't like that it's prosecutable because it's prosecutable. They got that wrong. We can't leave that way, can we, sir? So Roberts obviously was the one that had written the question that was to be answered on appeal, and then drove the discussion related to that throughout the entire debate over this. Very little talk until the very end about a former criminal president, Richard Nixon, although Ketanji Brown Jackson said, well, if presidents don't think they're going to be prosecuted and they've always enjoyed absolute immunity for anything they do in office, what was the Ford pardon of Nixon all about? What was that all about? Why did that have to happen if he had immunity? Now, Kavanaugh and others like Gorsuch jumped in with like, well, why don't pardon's good? We should just pardon everybody. That was the best thing the country ever had when Ford pardoned Nixon. You know? And then Gorsuch, pontificating and gazing at his navel the whole time, talking about, well, couldn't Trump, or I'm sorry, I don't want to use real names. Couldn't that president just pardon himself? Just do self-pardon? The fact that he even raised the specter of self-pardon tells you where this, again, neoconservative, unitary executive branch analysis is being driven home by these 5 to 6 members of the United States Supreme Court. Ketanji Brown Jackson stated it the right way when she said to the lawyer John Sauer for Donald Trump. Why are we even debating and trying to put in buckets what is a official conduct and what is a private conduct? Why does any of that matter? If the person commits a crime, right, a malum unse crime, a crime that we know because we see it, it's obvious, it's a moral transgression, if you will, suffused within the criminal law. Even if the person occupies the presidency, because the person occupies the presidency, shouldn't they be criminally prosecuted? And what she had a very good way to put that in her debate, her cat and mouse debate with John Sauer, the lawyer for Donald Trump. She said, you seem to be worried about the fact that a possible criminal prosecution for a person sitting in the Oval Office with that title, it may have a chilling effect on there being a robust presidency. I'm worried about the opposite, that there is no criminal prosecution for a person who commits crimes in the highest office of the land, with all of the powers of the presidency left unchecked, and therefore converting the White House into the seat of criminality. That concerns me. That world concerns me. And isn't that what you're creating? To which Justice Alito responded, turning everything upside down. Now we're in the upside down world. Wouldn't prosecuting a president destabilize democracy in some way, as opposed to wouldn't holding accountable one of the three co-equal branches of government and demonstrating that no person is above the law set by Congress and as explained by the Supreme Court, doesn't that promote stability of democracy? But now that I've given you sort of the overview of the debate, proud of what Kagan, Ketanji Brown Jackson, and Sotomayor did, and what will ultimately be very vigorous dissents about how this new constitutional proclamation forevermore will destabilize our democracy, will invite worse criminality than even what we saw with Donald Trump, or maybe Donald Trump too, now no longer worried about criminal prosecution. We saw what Donald Trump did when he thought there was a possibility of criminal prosecution. Could you imagine him back in office? I'm not making a dystopian view here. This is or apocalyptic view. Think about it. They make a ruling that anything within official conduct can't be prosecuted. What do you think Donald Trump does if he ever gets back into power? He does worse, more criminality, a kleptocracy like we've never seen before. And that's what the left wing, or the thinking wing, I like to call it, of the Supreme Court is worried about, as am I. Listen, the briefing is done. The oral argument is done. I'm going to get on with Judge Ludig, friend of the pod, so to speak, over the weekend. He submitted an amicus brief along with others. He's got a strong opinion about the oral argument. He was embarrassed by it. He thought it was reverse engineering on display. They wanted to help this president out, this former president out, and make sure that this case doesn't go to trial before November, which is going to be the result. I'll talk to him more. I'll bring it to you in hot takes like this one, special interviews for Legal AF. If you like what I'm doing on Legal AF, then you can leave me a comment and a thumbs up. It helps with the ratings and keeps us on the air. And then on Wednesdays and Saturdays, join me on Legal AF, the podcast at the intersection of law and politics. Join us. You'll find out why we call it Legal AF. And then pick us up on audio podcast platforms of your choice. If you like what I'm doing, go over to the Midas Touch YouTube channel. Look under contributors or playlists. Look for Michael Popok. You'll find my full body of work. I think it's 1,200 hot takes at this point. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown.